Good morning, ladies and gentlemen. It's my absolute pleasure to talk to you today about machine learning and the law, or put more provocatively, is my AI racist, or how not to break the law with machine learning and AI. Before we jump right in, I just want to briefly introduce myself. My name is Lukas Feiler. I'm a partner with the law firm Baker McKenzie, where I specialize in all things digital. So anything having to do with technology and the law is my daily business, and that is not by accident. In my previous life, as I'd like to say, I worked as a software developer and system administrator, so I do have a background in technology, and I have always felt that being able to work in the intersection between law and technology is among the most exciting things you can do, professionally speaking. Well, that's at least how I view it. And having said that, I want to jump right in and talk a bit about what it is that makes us worry at times, whether we're, let's say, teaching the right things to AI and machine learning solutions. You will certainly start off with some kind of concept, an idea of how to automate something, how to teach something to a machine in order to, at the end of the day, generate business value. I know from a technical perspective, we very much enjoy the technical solution that we're building here, but at the end of the day, it's still a business value that we will have to generate here. This is, after all, why somebody's paying for it, for whatever solution we're working on to get developed. So how do we get from the concept, the idea, to the actual generation of business value without facing too many legal problems? Put another way, how not to break the law with AI and machine learning. It starts off by looking at how we collect, how we identify the right data. We will want to train our machine learning algorithms with data that actually teaches the algorithm the right things. And getting hands on that valuable data is not always that easy. To begin with, data protection law, and in particular in the EU, the General Data Protection Regulation, or GDPR, imposes significant limitations on the collection of personal data. So it's not always as straightforward as simply finding the data. You have to make sure that, legally speaking, you are actually allowed to use the data for machine learning purposes. That is why in many projects, companies try to first anonymize the data before they feed it into a machine learning algorithm. The problem with anonymization here is that you might reduce the value of the data to a very significant extent, and even in some cases to the extent that the algorithm might not be learning the right things from the data. So something that in recent years was pushed quite significantly and with significant success is synthetic data. That is data that is generated from the actual personal data that has the same statistical properties as the original data set, but does not contain a single identical record compared to the old data set, and otherwise is not containing any other personal data, only synthetic data that, speaking overall, looking at the entire new data set, has the same statistical properties. That is a hugely promising way of using data for machine learning purposes in a data protection compliant way, while at the same time making sure that we're training the algorithm with high value data, allowing the algorithm to learn as much as possible and to learn the right things. If that's not an option, and we have to use actual personal, or want to use actual personal data to train our algorithm, then in many cases the question is, can we, in particular under GDPR, do so without consent of the data subjects, because getting consent is very difficult under the GDPR, and something typically you would want to avoid. If at all possible, try to find a way of realizing your machine learning project without having to ask for consent. There are other options under GDPR as well that might allow you to use personal data for machine learning. The last resort really is asking data subjects for consent. Not only is it difficult to get, you also have to document it. You have to prove that you have obtained it. The data subjects can revoke their consents later on, again, making things difficult. So this is kind of the first legal hurdle here, finding the right data. Because if you don't, the second step, training the algorithm, can go wrong in a very serious way. Because at the end of the day, the question is, what does the algorithm learn? What am I teaching it? And that depends on the input data. If I provide the wrong kind or simply not sufficient input data to the algorithm, it might infer things from the data set that I'm providing to the algorithm that simply aren't reflective of reality. But nonetheless, the algorithm might deploy these learnings then in real life, and might suddenly do things that you simply would not expect an algorithm to do, simply because you have fed it the wrong or insufficient data. Where it becomes particularly risky from a legal perspective, something we will look into in further detail, is what if my algorithm becomes a racist? What if, or otherwise, implements systemic discrimination in your software? If it learns from the data that you provided with, that people exhibiting certain characteristics, certain backgrounds, should be treated differently than other people. And therein lies a very significant challenge, not just from a legal perspective, but I would say from the perspective of society in general. Once we're fully automating a decision, we're also automating parts of it that we may actually not agree with. That is not to say that an algorithm would be discriminatory by nature, or also not to say that humans wouldn't be capable of making equally bad decisions. I would go even further and say that humans, by and large, make bad decisions. That's why it makes so much sense to automate them. Humans have a proven tendency to act irrationally. There are studies out there basically showing that any job interview is decided within the first 10 seconds. Why? Because irrespective of how many HR trainings a manager gets, he or she will still have a gut feeling about the job applicant sitting from them across the table. Do I like them or not? And that kind of feeling doesn't go away for the rest of the job interview. And it's ultimately that gut feeling that decides over whether or not somebody gets hired. And that's something where people are on a daily basis discriminating unfairly against each other. However, they're doing so in a way that is very difficult to prove and rather little regulated. However, once we're automating things, even though the quality of the decision might be equally bad or equally good as a human, or I would argue, generally speaking, the decision quality will be a lot better than the decisions most humans take. But nonetheless, once we're automating it, it can be audited. Statistical analysis can be done more easily. And that makes the automation a lot easier to attack for any plaintiff, for anyone suing the company alleging discrimination, because, well, they can go after the algorithm and have a way of proving that there is systemic discrimination. So it's not just that that automating makes things more efficient and quicker. It also makes things provable. You can actually, at the end of the day, find out what the process actually looks like by looking under the hood, if you will, or simply running a lot of cases through the algorithm and looking at the statistical distribution of the outcome. That is difficult with a regular human process. So it's I think from the perspective of society valuable to keep in mind that automating things in many, if not most cases, produces a higher quality of the decisions, but nonetheless, from a very individual perspective of a company automating the decision using machine learning, the risk might go up. Even though the quality of the decision is better, the risk might still go up. Then it's now provable what the company does and doesn't do in terms of its decision process. And it is this automation that the law regulates particularly severely. There is, of course, general civil liability attached to making bad decisions. And when you're automating it, as I said before, it becomes provable. Plus, the automated decision in itself, as you'll see in a couple of minutes, is something that the GDPR regulates specifically. So a fully automated individual decision is something that is not just possibly easier to prove for a plaintiff if something went wrong, but the law actually provides very specific rules on fully automated decisions. Currently, there's a lot of discussion in Brussels going on about regulating AI. My answer to that would be, we don't need a new law on AI. We actually already have one. It's called the GDPR, specifically Article 22 of the GDPR, already contains very specific and rather strict rules on how to use AI to automate a decision. This is something we'll be looking at in detail. And making sure that you travel the entire way from the concept, the idea, to the business value without breaking the law is what I want to talk about in more detail for the remainder of this presentation. Starting out with discriminatory algorithms as a privacy risk, as a GDPR risk. Because you might say, well, so what? I have an algorithm that discriminates against a certain minority. Statistically speaking, probably the current human processes do the same thing, have the same effect. So what's the additional risk? Well, the additional risk is that through automation, you are processing personal data in a way that creates additional liability for the company. First off, discrimination can happen in many different ways. Let's assume you're feeding your algorithm with data that seems to suggest that Norwegian sounding last names indicate that the people bearing these names have a willingness to pay higher prices than people who do not have Norwegian sounding names. So you're basically teaching the algorithm that people who are from Norway should pay more. That sounds a bit like discrimination, because it is. It is. You can replace Norway with any other country, in particular countries where people with less economic possibilities, fewer economic possibilities live. And I think it becomes quite clear that examples like these are classic discrimination examples that are indeed prohibited under the law. So having all people that are of a particular origin, let's say Norwegian origin in my example, pay more than people from other countries, that's simply discrimination by any standard. And what's the problem here? What might be going wrong here? Well, in most cases, it's confusing correlation and causation. The fact that in the data set that you're training your algorithm with, people with Norwegian sounding names might have a willingness to pay higher prices, might very well be, but the one is not causing the other. Within your data set, yeah, there might be a statistical correlation there, but that does not mean that this is a good idea to base any decisions on. So when training an algorithm, I think this is absolutely a key point, you need to have good data scientists. You need people checking what it is that you're teaching an algorithm. Otherwise, it is indeed very likely that your algorithm will be learning the wrong things, like discriminating against people of Norwegian descent. That would simply be prohibited, for example, in Austria under the Equal Treatment Act. That's a clear violation of the law. You might say, well, the Equal Treatment Act, the Gleichbehandlungsgesetz, doesn't carry significant penalties. It's just a few thousand euros. We'll live with that. Well, think again, because violating the law, specifically equal treatment legislation, would render the entire processing of the personal data that your machine learning algorithm does with every new decision that it makes illegitimate. Because under privacy law, you need to have a legitimate processing purpose. And that is interpreted as meaning that you are not allowed to violate the law in any way when handling personal data. If you do, your processing purpose is not legitimate anymore. And that violates one of the basic principles of the GDPR, the principle of purpose limitation. And the violation of that principle is, as most other violations of the GDPR, subject to a fine of up to 20 million euros, or 4% of the global annual turnover of the entire group of companies. So we're talking real money here. Having a racist algorithm or otherwise illegally discriminating algorithm therefore means that you're not only violating equal treatment legislation, you're at the end of the day committing a privacy violation. That, as we all know, under the GDPR carries very, very hefty fines. And that simply means that making sure that the algorithms that you built are non-discriminatory is not something that you only should be aiming for from an ethical perspective, but in addition to that, you should be aiming for in order to ensure legal compliance and avoid very, very significant financial risks in the form of penalties under the GDPR. When we are fully automating a decision, even where we manage to make sure that our algorithm is non-discriminatory, we, as I mentioned in the beginning, we are facing very specific regulatory requirements in the form of Article 22 of the GDPR. This is actually a provision that more or less mirrors a provision that we already had in the Data Protection Directive that was passed in 1995. So this is actually law that we have had on the books for really 15 years or longer, and was indeed written with a lot of foresight. As you'll see, it's regulating many aspects of machine learning in a rather privacy-friendly way. From a technical perspective, I have to say in a way that makes it very difficult to implement fully compliant machine learning projects, at least for most applications. So what is it that the law requires of us? Firstly, the law takes a very restrictive approach to fully automating individual decisions to begin with. Any decision that is not a statistical analysis of a great number of people, but really something that is decided with respect to a particular human being with a particular data subject. Here the law says that as a principle, any automated individual decision is prohibited if it either has legal effects for the data subject or similarly severely affects the data subject. So what is it that we're actually talking about here? Well, it has to be a fully automated decision. So without any human intervention, a machine, software, is deciding something. And that something has to have either legal effects or otherwise severely affect the data subject. So legal effects could, for example, be the termination of a contract. Let's say you are an insurance corporation wanting to determine which of your insured customers pose the highest risk, and you want to get rid of them. You want to terminate all their insurance contracts since, well, you're looking to reduce your risk level. And you're fully automating that process. An algorithm looks at all the prior claims that were made by your customers, and based on that and a number of other criteria, it fully automatically produces notices of termination that get sent out to the respective customers. Well, that's an individual decision that produces legal effects, and as a principle would be prohibited. Same goes for refusing a line of credit to a customer. If a bank decides in a fully automated fashion not to give any credit to a particular data subject. An example here, I'm not going to name the bank, but it's about 4 years ago that there was a story in the newspapers that all employees of the Austrian labor market service, IMS, who had a bank account with that particular unnamed bank, had from one day to the next set their withdrawal limit for their bank accounts to 0. So they were not able to take out more money from their bank account than was on their bank account. So they could not overdraw the bank account from one day to the next. And nobody knew why, at least officially nobody did. And then the next day there was some kind of explanation of a technical error. I am 100% sure that what happened there was that some algorithm figured out that people who receive money from the Austrian labor market service that is paying unemployment money to people, well, have to be unemployed. It's just that the algorithm didn't figure out that some of the people get money from that institution because they actually work there. So the algorithm incorrectly inferred that getting money from that institution means being unemployed, whereas it disregarded some people just, well, have an employment contract with that institution. Generally speaking, against the law to implement any such decision. Also, a non-hiring decision in an employment context, exactly the same thing, because it would severely affect the data subject. You actually do have companies, whether they're disclosing it or not, out there in the market that receive so many job applications that they have to automate the rejection process, because it's simply not cost efficient for them to look at 300 CVs. It's rather software doing that and only filtering out the 15 that are relevant, and only those get looked at by an HR professional. Last example is price differentiation. And that is the practice of charging different prices to different customers. You might say, well, when does that happen? Well, example, every time you buy an airplane ticket, all the airplane broker platforms do implement price differentiation algorithms. It starts out with real simple stuff, like if you're using Internet Explorer, you get a cheaper price than if you're using Safari. Because, well, statistically speaking, people using Safari own an Apple hardware, and that typically means they're able to pay more for things. If you're able to afford an Apple device, well, chances are you'll be willing to pay more for an airplane ticket than somebody using Internet Explorer. Is that true in all cases? No, absolutely not. But statistically speaking, yeah, probably there's some truth to it. That kind of price differentiation too severely affects the data subject. I said that these kinds of decisions in principle are prohibited. Where there's a principle, there's an exception. So here too, by way of an exception to that rule, it is permissible to fully automate such decisions if one of three criteria are met. First, if it's either necessary for the conclusion or performance of a contract that the company has concluded with the data subject, and no sensitive data is involved, no health-related data, no data about sexual orientation, political opinions, etc. So, for example, we have a client, an insurance corporation that has brought to the market an insurance policy for vehicle owners that is based on the driving behavior of the owner of the car. And it is indeed looking at the driving behavior in real time. So what happens is that you have software running in your car. The car has, all cars today do, has integrated a SIM card that has an uplink to the internet and is on an ongoing basis uploading data about your driving behavior to the insurance corporation. And the insurance corporation is taking in real time a decision about whether or not to increase or lower your insurance premiums. Why is it doing that? Because, well, you asked them to. That's the kind of fundamental basis of such a type of insurance contract. You're going to the insurance corporation saying, I want to pay insurance premiums based on my driving behavior. Typically because, well, you think that you're such a great driver and expect to be paying less than the average driver. That's why you're asking for this insurance product. Well, if you do, then that makes it necessary to perform the contract, to look at your data and decide in a fully automatic fashion, because that's a kind of decision that a human couldn't even take. It depends on too many data points, whether or not you are driving safely. And if you are, yes, your insurance premiums will be going down. And accordingly, here, the insurance corporation would be allowed to take fully automated individual decisions, in particular using AI and machine learning. Second option, not really one in real life, is if national law authorizes the fully automated decision. Doesn't happen, at least not in Austria or Germany. There is no law that authorizes a company to fully automate any decision. The third option, in many cases, the only one that really works, is the express consent of the data subject. So you really have to ask the data subject, are they fine with it? Do they want this? And if they say yes, well, then you're allowed to fully automate it. Otherwise, you're not. So what does happen in real life, given that the law is prohibiting the automation of these decisions so severely? Well, what happens in let's say 49% of the cases is that simply the companies ignore the law. I'm being honest here. Many companies that fully automate decisions, firstly, do not even know that they have an issue with the GDPR, and if they do, they simply act as if they didn't. The other 48% of cases are indeed compliant with the law by doing something you could call a circumvention of the law, but it's still perfectly legal, and that is artificially de-automating the process. The company knows this can be fully automated, but what they do is they put a human between the decision produced by the machine learning algorithm and the data subject. It's, for example, you go to a bank and ask for a loan, and the bank manager enters all your data into his or her computer, and out comes basically a decision. It's basically the computer telling the bank manager what's going to happen here. But nonetheless, you will not be presented with some kind of final decision that will be staring at you from the screen, but rather your bank manager will be reading that decision on his screen or her screen and will politely be turning to you and will be telling you that unfortunately he's feeling very sorry about this, but he has thought this over and he's not able to offer you a loan. Very sorry, and he has thought about this, but he doesn't see a way how. In reality, it's of course the machine making the decision, but it appears as if it was the bank manager making it. Of course, ideally, the bank has some kind of policy sitting in a drawer that says that, of course, he can overrule the decision. He only has to go to the manager of the branch office and ask for approval. And of course, it would be granted if merited, et cetera, et cetera. But in real life, come on, you know, it's the machine making the decision. Nonetheless, legally speaking, as long as there's a policy sitting in the drawer saying that the final decision is being made by a human, and it's just a recommendation that a machine is giving, it's not a fully automated decision and not subject to these severe restrictions. Nonetheless, there are cases, and I'd say these are the remaining 4%, where you really, really have to fully automate it and really want to make sure that you're actually compliant with the law. And that means not only finding one of these three options here as a legal basis to justify the fully automated decision, it also means that you have to comply with additional requirements that the law provides for automated decisions. And that is first that you have to grant data subjects certain rights. And that starts with the right to human intervention. You have to make it possible for the data subject to basically say, oh, whoa, hold it. This might be all fine and well, but I want an actual human being to take a look at this. And the data subject has to be able to express his or her point of view and to ultimately contest the decision. So it has to be possible for the data subject to make somebody, an actual person, look at this and evaluate the decision. For example, if I applied for a job and I got back a fully automated answer saying, no, I would probably be a bit frustrated without any kind of explanation if I felt like I was perfectly qualified for the job and all I get back is a no. Well, I might have a couple of questions. So I would want to ask the machine why, and would want to express my point of view here. So let's, for example, assume that the algorithm deciding about my rejection here has found a photo that, using a facial recognition algorithm, matches my face, and has the machine learning algorithm has determined that it shows me in a state of complete drunkenness, and therefore I'm not reliable enough to be hired for this very serious job. Well, there might be an issue with this, and I might simply have a point of view here I want to present, and that is, well, that's not me, it's my identical twin brother. Because I do have an identical twin brother. He has 2 kids and doesn't drink, but that's beside the point. It could be him, and let's say it was him in that complete state of drunkenness and not me. And I want to be able to contest that decision. The machine learning algorithm that is being used here might simply not have taken into account the fact that I have an identical twin brother. So I have to be able to make a human being look at this. That is not the only thing that I have to do in order to comply with the law. Somewhat connected to it, as you'll see in a second, is the requirement to be really transparent about the decision process. Quite specifically, we first have to inform the data subject that there is, to begin with, something such as a fully automated decision-making process in place here, and we have to disclose the logic involved. specifically, a guideline from the European data protection authorities, from the European Data Protection Board, says that the information disclosed has to be sufficiently comprehensive for the data subject to understand the reasons for the decision. And that kind of makes sense. If it should be possible for me to contest the decision, I have to know what the decision was based on. If the software isn't telling me that it found a photo of me on the internet and has concluded that this was me drunk on a couch somewhere, well, how should I be able to argue that it's not me, but my identical twin brother? So the software has to explain itself. And that leads to the challenge of explainability of AI. As many of you will know, that is not an easy task. Most machine learning projects that are being implemented these days do not implement any explainability features. From a cost perspective, as well as from a timeline perspective, it's usually plus 100% of the effort to make your machine learning algorithm explain itself, because that needs quite some additional thinking that has to go into this project. Nonetheless, strictly speaking, this is what the law would require. That the fully automated decision is not just being taken, but the software is able to explain why. Only then is it possible to contest the decision. Also, the significance and consequences of the decision have to be explained in advance. All these disclosure requirements lead to an obvious conflict with protection of your trade secrets. If you're disclosing all the details of how your algorithm works, well, you might end up disclosing things that are very valuable to your corporation and might be helping the competition to catch up with you. The GDPR does allow us to withhold certain information that ultimately constitutes a trade secret. In Austria, we have even more specific legislation that allows us to not disclose this information. Nonetheless, it's a difficult balancing act. How much is necessary to disclose in order to make the decision ultimately explainable, and what constitutes a trade secret that I simply do not have to disclose? There are no clear boundaries here. Also, no court decisions or data protection authority decisions on these issues yet. But this is certainly a red line we will have to walk in order to make sure that our AI is not breaking the law. And with that, thank you so much for listening to my presentation. And I really absolutely look forward to any questions you might have. Thank you.